anybody's failure to appear here today to object to the motion, and in light of the rental balance that is due to Scio Farms, $13,880.44 at present, we would be requesting an order allowing Scio Farms to demolish the manufactured home on site.
The main thing right now is my air condition. My air condition isn't working because I don't have an air condition unit. So that's why the issue started from the beginning, because of the repairs.
Arbor Woods versus Angela.
Buckle up, guys. Today we are diving straight into a courtroom moment that wastes no time turning tense. The hearing opens with a shocking request to demolish a manufactured home over unpaid rent, immediately raising the stakes. Before the court can even settle in, the tenant fires back with claims of no air conditioning, unfinished repairs, and a child suffering from asthma. In under 30 seconds, this case transforms from a routine motion into a high-pressure clash between financial obligations and urgent living conditions.
Cater. Hello, Miss Cater.
Hello.
All right, I set this for a hearing because it was coming close to the judgment. How much do you have owing on her account at this point?
Your Honor, the ledger reads $6,923.50. I know that there was some money at escrow that was released on or about April 25th when Ms. Cater filed her first motion. The court denied the motion but did release escrow. According to the motion, there was $1,600 released at that point. We don't have that money yet. And then
so you don't have the 16
correct
that was released.
Correct. And then the second motion indicated 1 month's rent was deposited, but I'm not entirely sure how much was, and I assume that's still in the court's escrow.
So I'm just trying to track this because did you receive $500 from us?
The ledger, Your Honor, shows a $1,500 payment on 4/10, a $2,100 payment on April 24.
Got it. Okay.
And that left a balance of $52,1775, and then obviously the May rents come due.
Gotcha. So you got the 21 in that one. Okay. And then I have, well, that's that one. Reading, that's 15, that's closed, that's closed, that's closed. There's 16 in the 18. Great. Okay. So what I have currently in escrow is 3463.
Okay. So 3463 plus.
Well, and I just want to make sure I'm clear on this. The 16 that I ordered released, they just haven't released it yet.
That's correct.
Okay, that's where I was getting confused.
Okay.
So that includes the 16 that I ordered released.
Gotcha. Okay. So there was another
63.
Putting the total at 3463. Okay, that makes sense.
3463.
The judge takes control and begins carefully untangling the financial mess. We watch as escrow payments, partial releases, and ledger entries are dissected line by line. There's confusion, recalculation, and visible effort to make sure nothing is missed. This moment shows how quickly a case can hinge on exact numbers, not emotions. The tension quietly builds as everyone waits to hear what the real balance is, knowing that a few $1,000s will determine what happens next.
So if the balance you have now, if I don't have anybody to do my math here.
I'll do your math.
So the amount that's currently owing is how much?
$6,923.50.
And what did I tell you?
You have 3463.
So I've got 3460 and 50 cents left over.
Oh, not, yeah.
Yeah, how much?
34.60 and 50 cents is the remaining balance.
34.
60 and 50 cents.
Okay. And that's through May.
Correct.
All right, Ms. Cater.
This is the turning point. After all the math and verification, the judge pins down the true amount still owed, $3,460.50 through May. The number lands heavily in the room. It's no longer vague or disputed. It's precise and final. From this point on, the case stops being about confusion and becomes about whether the tenant can meet a very specific financial demand within a very tight deadline.
All right, hello. So the main thing right now is my air condition. My air conditioner isn't working because I don't have an air conditioning unit. So that's why the issue started from the beginning because of the repairs. And I understand the other repairs, I guess, aren't going to be done. I'm not sure because after they came over and took pictures in March and I haven't heard anything and they closed out my things. So I just really need hot water and some AC because my AC is registering at 81 right now and I have a child with asthma. So I really need that done.
Miss Cater, couple things so that we're clear.
With the balance clear, the tenant shifts back to the human side of the story. She explains the heat inside the home, the missing AC unit, and the risk posed to her asthmatic child. The courtroom tone softens briefly as the reality of daily living conditions comes into focus. Still, there's an underlying sense that sympathy alone may not be enough to change what's coming.
I am not, certainly those issues could be dealt with, maybe. But I issued a judgment on this back in March. I initially denied your motion to set it aside.
Correct.
Right, because it wasn't, the judgment wasn't going to be paid and there had been additional rent accruing.
Okay.
The only reason that I even set a hearing on this was because when you came with the second motion, there was then a substantial additional amount paid.
Okay.
That was going to get you close to getting yourself caught up. All right. My only question in whether I let this judgment continue or set it aside are no longer, from this court standpoint, the repair issues.
Okay.
It becomes an issue of getting this paid.
Okay. So
Okay.
It can be paid by the 30th.
That whole amount.
I can have $3,000 paid for sure by the 30th, and then the other.
Say what? Say it again.
I can have $3,000 paid by the 30th. And then I can have the remaining paid by the 6th of June.
What about the June
But
rent?
what about your June rent?
I can add that with the June. I was just going to say I can add June's rent with that.
The judge responds firmly, drawing a clear boundary. He explains that while repair issues matter, they are no longer the deciding factor in this case. A judgment was already entered, additional rent has accrued, and the court's focus is now squarely on payment. This moment makes it clear that the clock has been ticking for months, and patience from the bench is wearing thin.
Ms. Cater, I'm going to be honest with you. I really don't want to do that.
Okay.
I know in the past you always come up with it, and I get that. But at some point, there's got to be fairness to the landlord in this case. And, they've got to reconcile everything, get everything paid. And here's what my problem is with what you're telling me, is that on this, you're asking me to allow this case to move into June. And I'm not, I don't want to do that.
Okay, well,
hang on.
Yes, sir.
This 34, 60, 50.
Yes, sir.
That I got to have that paid in May.
I can do that May 30th.
Because they'll let you know, the only reason I set the hearing is you had brought in a substantial amount. And quite frankly, I thought when we get here today, she's going to have that additional amount. But you don't have it. But I'm not going to keep extending this out. I issued this judgment back in March.
Okay. I can have it paid by May 30th.
Here's what I'm going to do then. And this is also, I'm sure, going to be over plaintiff's objection, but it's what I'm going to do. What's the time on the 30th?
On the 30th, that's 2 weeks, it'd be 2 p.m.
I'm going to adjourn this to May 30th, 2025.
The tenant proposes a plan to stretch payments into June, hoping for more time. The judge immediately pushes back. He emphasizes fairness to the landlord and refuses to let the case drift forward again. This exchange highlights a critical courtroom reality. Good intentions and promises mean little when deadlines have already been missed and obligations keep growing.
At 2 p.m., we're going to release the 3463 escrow to plaintiff today. So can we send a message down there, try to get that out to them? And then you're going to pay $3,460.50. I want that paid directly to the landlord. And Ms. Cater, are
Yes,
you going to be able to get that paid prior to 2 p.m.? I really did paid prior to noon
it will
on
be.
that day.
It will be. Yep.
All right. So I'm going to put by noon on the 30th. All right. Now, just so that I'm also clear, Ms. Cater, and you know, I'll listen to you. I'll hear anything you got to say. But if that's not paid, I'm done. I can't
Okay.
much else.
So I have a question. What am I supposed to do regarding my repairs? How am I going to get
All
those?
right. Submit the repairs
I've done
to
that.
them.
I've done that.
All right.
I've been doing that
Here's
since I
what-
moved in, Your Honor.
Okay. And you say it's
Pass the
air
repairs along
conditioning?
to my client as well. I've noted that there's no AC unit. My understanding, this is a brand new home.
It
Your
is.
Honor. And so air conditioning units were put on order. My understanding is that there are many that are scheduled to be installed on the 22nd. I don't know if Ms. Caters is on that list. It's very possible hers is. I don't know for certain. I'd have to verify with my client. So I suspect the AC unit is coming up within the next week. As far as what was specifically on this work order, Ms. Cater says was closed out, I'll check with my client, let them know that she's stating that those issues are still outstanding. One specific thing Ms. Cater referenced today was something about hot water. I'll make sure to address that with my client today.
Okay. All right. Fair enough. All right. So hopefully we can get those issues resolved as well as get the monetary issue and let you try to get a fresh start come June, Ms. Cater. Okay.
Mm-hmm.
All right. Okay.
Here comes the ultimatum. The judge adjourns the case to May 30th at 2 p.m., orders escrow funds released immediately, and sets a hard requirement. $3,460.50 must be paid by noon that day. He makes it unmistakably clear that if the money isn't paid, he's done extending grace. The warning lands like a gavel strike, leaving no room for misunderstanding.
The Haven versus Mary Heineman.
Anything for the plaintiff?
What's your name?
Mary Heineman.
All right. Where are we on her case?
Oh, me or you?
Go ahead.
I've been in communication with Hawk and sent in all the documents that they requested, paid it under 3,000. So I'm waiting to hear what their decision will be.
All right.
I also, sorry, I
Go
start
ahead.
a new job next week. And I won't get my first paycheck until June 15th, but my mom said that if I can get the balance paid off, she'll pay for June. So there is some plans.
Your mom said that?
My mom said that, yeah.
Is that who's with you?
No, that's my
Oh.
girlfriend.
Pardon?
She's also going through the process. That's my friend.
Got it. Okay.
Neighbors,
I thought maybe they were sitting there where they're just chatting. I thought I was here. Okay. I know that there were people that were in the system, but I also know that there might be funding issues. So when people are telling me that, I'm not sure what to take that as or.
Yeah, and I'm sorry, especially with this case, I don't have anything more specific to add other than confirming with her permission that she is working with Caitlin over at SOS. So if Mr. Fink is aware or has received any communication, that would be the caseworker that's been assigned.
All right. Thank you. What are you going to do on this?
Didn't hear that she's going to get the money.
Correct.
May we have one moment?
Sure.
Will your mother pay?
I can't
Yeah,
confirm
you
that.
stay, and by the time we came back in June, you'd have a job and a paycheck.
Right, but I can't speak for her, so I don't know, but it's possible. But then
Are
what
you
would
the
that mean?
youngest?
No, I'm the oldest.
Oh,
It's possible, but I mean, I guess it depends on.
I got 6. I know how this works. Baby gets everything.
What are we doing?
I mean, my preference would be to push it as long as possible, but
Of
obviously.
course.
How about a redemption date of the 30th or the 31st? That's a Saturday, so it doesn't make that much difference because it'll be Monday before we come back.
So you think you can get that? Let me ask you this. Worst comes to worst, you think you can get this paid by the end of the month?
I'm not certain, honestly. I mean, I'm hoping Hawk will have the funds. I know that they're short on funds. I'm doing what I can with them. I can't say 100%.
When's your first check?
June 15th. I know it's a
Amy, I'm going to put you on the spot and just ask you a question. Answer it as vaguely as you want to, but is there anything on the horizon that might look promising and make my job easier?
I think I just want to say that we've also heard that she won't be helped. So I don't know if that helps anything.
She
And-
won't be.
Right. I haven't heard that either. So,
Oh, gotcha. Oh boy, Bauer, what?
I think I've mentioned this to the court before. I became aware of a nonprofit that does a loan for a small amount of back rent. And I think the interest rates are super low and this person has like 3 years to pay it back. So I could try to send this flyer if this, I don't know your name, if she wants to try to explore that option.
I'll explore whatever options are available. I don't know if I'll qualify, but yes. I've also been in touch with or reached out to Friends Indeed. I'm calling all my friends. Like I'm doing it.
I got you.
If you want to wait here, I'll try to find the flyer.
Okay. Great.
Oh, I found it.
Sounds like you're going to adjourn it to the 30th over my objection.
Yeah, I am. May 30th, 2025, 3 p.m.
A new case enters, bringing fresh uncertainty. This tenant explains job changes, delayed paychecks, and reliance on outside assistance programs. The judge listens carefully, probing whether any real funding is on the horizon. Despite the uncertainty and vague timelines, the court grants limited breathing room, balancing skepticism with cautious patience.
All right, give you a little bit of breathing room. Get that flyer, see if that works out for you. See what...
Thanks, you too.
Court calls the case of Sile Farms versus Lawana Tut. She's no. Yep. Here she. Okay. Something's wrong with their camera, but oh no, there she is. Oh, hello, Miss Tut. Okay, where are we on this case?
With costs, Your Honor, $5,931.20.
So you were to pay. Last time we were here was May 2nd. You were going to pay $1,500 by the 9th. Did that get paid?
I had sent them, I was in the hospital and I had someone deliver a personal check. They wouldn't take that. So I did have someone drop off today a certified check for $2,000. And then the last time I had submitted a request for my employer for assistance with the remaining balance. That has been approved. I am just waiting to receive the funds, which I expect to have by next week.
Okay, so I think Sile Farms is here. There
Yes.
she is.
Patty, do you have that $2,000 payment? Yeah, okay. Looks like we
Okay,
got
so
it.
we have
Your
the
Honor.
2,000. And then you had mentioned before about your employee assistance program, and that's going to pay the balance?
Yes.
Okay, so when are they expecting?
Sorry. I'm so sorry.
It's okay.
They didn't give me a date. They just told me that my request was approved. They would pay the remaining balance, and I'm just waiting to receive the check from them. And I believe that they have sent it, but I haven't received it yet. So I'm guessing it will come within the next few days.
Okay, so here's what I'm going to do. I'm going to do kind of the same thing I just did with Ms. Clemens for you, okay? I'm going to find no tribal issue after after a hearing in this matter. I'm going to grant a judgment for possession in
Your Honor,
the amount. Yes.
you have to grant a judgment because I am going to be moving soon, and I would, don't want a judgment on my record that will maybe prevent me from
when are you going to be moving?
getting other housing. I have to relocate to North Carolina. I'm sorry, I'm not doing well health-wise.
Okay, all right. I'll tell you what. Let's do this. I will grant the judgment. I'm going to trust you. You did too. I know you've been in the hospital. You told us about your employee program. I'm going to trust you. I'm just going to adjourn this case out to the 30th. Okay? And if your employer gets it paid, then it's likely this will be dismissed then. Okay, I'll do that for you.
Thank you so much.
Okay, and I'm doing that over the objection of plaintiff, of course, but that's at 2 p.m. on the 30th.
Another tenant appears, this time citing hospitalization and employer assistance that's been approved, but not yet received. A partial payment is confirmed, lending some credibility to her claims. The judge chooses to trust her, adjourns the case, and does so over the landlord's objection. It's a rare moment where health issues and documented effort tip the scales toward temporary relief.
Okay, Ms. Todd.
Thank you.
Court calls the case Whitaker Oaks versus Kathleen Short.
Hi,
and
I'm
also
here.
Brian Pollard. Okay, she's here. How much do we have owing?
Your Honor, excuse me, the ledger balance is $4,241.61. Your Honor, Ms. Short was ordered to pay $800 to Whitaker Oaks. She did do that, Your Honor. My client hasn't applied it yet because there is an ancillary issue I wanted to bring to the attention of the court. Your Honor, Ms. Pollard's lease agreement with the property has expired. A notice to quit actually was previously issued and did expire on May 10th. And so my client is intending to pursue termination of the tenancy to recover possession of the unit. I know that that issue obviously is not before the court today. This action is for non-payment of rent. My hope was, if it please the court, to speak with Ms. Short in a breakout room and to see if we can reach an agreement with respect to both actions in light of the situation.
Okay. All right. Ms. Short, do you want to do that? Did you understand what counsel was indicating?
I have no idea what that means, but I will do whatever.
Here's the thing. You're here on a non-payment of rent case. Your lease has expired. They're going to seek to terminate your tenancy or to have you moved from the premises. That
Even
case
if I
has
can
not.
pay.
All right. Short.
It's fine. I'm listening. Just keep going.
All right. That case is not before me today, but I don't know. Has it been filed already, counsel, or no?
Probably is with our office to file. I don't know that anything has been submitted to the court yet. I would say, Your Honor, that to the extent a judgment entered today for non-payment, we would only be seeking a judgment through the April 30th charges because my client would intend to proceed with that filing and would not want to accept payment that would jeopardize that case. And so that's why I was proposing perhaps a conversation with Ms. Short to see if we couldn't reach an agreement that would negate the need to file the other case, as well as to potentially negotiate a move-out date.
All right. Ms. Short, let me just say this. You don't have to speak with the attorney if you don't want to regarding that case. It's not before me right now. Okay? I just wanted to make sure that you understood what she was indicating to the court.
I mean, I do
Okay.
understand, but I understand. Yeah.
Okay, Ms. Short, here's what I'm gonna do, okay? That case is likely gonna be filed. I'm gonna put this out a week, let you kind of wrap your head around all of that, okay? About what's been said today. And we'll come back, and then if you wanna either get an attorney or somebody to help you out with this, or to then talk with Ms. Dornbush on that date next week, then we could make that happen, okay? Because I realize this was something new you just heard, and I don't want, right?
This case takes a sharp turn when a tenant learns, live in court, that her lease has expired and eviction proceedings are looming. The surprise is obvious. The judge slows everything down, recognizing that this information is new and potentially overwhelming. The tension shifts from money to housing stability, with the future suddenly uncertain.